Well, hello, everyone. My name's Craig Ralph, and I'm joined by Erica Bedford. We represented the respondents along with the team at Oakwood Solicitors before the Supreme Court and as appellants before the Court of Appeal, and prior to that, of course, in the High Court. Now, I think we had down something like 800 odd people that were going to join this. Now, my high-level skills at technology, looking at the screen, don't actually tell me how many people we've got online now, but before we came on, I was told by our moderator in marketing that there was about 300 people had joined. So I'm just going to give them sort of 30 or 40 seconds just to make sure that those that come on the dot, so to speak, but might be experiencing little bits of technology glitch can get into the room. So again, how long is this going to take? Well, we've not timed it, Erica and I. So the reality is it's going to take as long as it takes us. I don't think it's going to be overly long. In our own heads, we kind of aimed for about 40 minutes. It could go shorter. It could go a little longer. So bear with us. I hope you find it useful, and I hope you find it interesting. Okay, so we're going to look today at the impact of the Supreme Court's judgment. The Supreme Court held, contrary to that which the Court of Appeal had held, that for the purposes of Section 70 of the Solicitors Act 1974, there's a requirement for agreement to pay the sum specified in the bill, and it is not, as the Court of Appeal had found, met by a mere agreement to the transfer of the monies generally, followed by deduction by the solicitors of a sum towards their cost shortfall from any monies that there may have been holding in client account. What that means is, therefore, that absent that payment, as the Solicitors Act terms it, then the 12-month limitation period under Section 70 isn't triggered. It doesn't start to run. And of course, what that means in practical terms is that absent that limitation period on a statutory assessment being commenced by the client or indeed the solicitor, then there is potentially open house for a request for an assessment, obviously subject to the client being able to establish special circumstances. But it opens up those cases which some solicitors may well have concluded were long settled and had presumed them closed. It opens them up, at least in principle, to a challenge for a Solicitors Act assessment. So what does that mean in practice, and what, if anything, is the impact upon practitioners? Well, there we have it up on screen, what Section 70 subsection 4 says. It's abbreviated. We've abbreviated it. It's the power to order assessment shall not be exercisable after the expiration of 12 months from the date of payment of the bill. The word that all this turns on is, of course, payment. Now, let's go back in a little bit and just make some principled assumptions. Let's assume, for the purposes of this, that the retainer that you have with your client permits a payment of costs and damages direct to the solicitor. So, in other words, there is a clause within your retainer that, in fact, allows you to collect in these monies that are, in effect, the client's monies direct into your own client account. Let's also presume that it imposes the retainer an obligation upon the client to pay any shortfall for costs incurred over and above those recovered from your opponent. And let's also assume that the retainer provides for that shortfall to be settled by deduction. If all those matters are in place, then the question is payment for the purposes of Section 70, subsection 4, in particular, in the case of the common practice, certainly in what we see in bulk personal injury or clinical negligence cases, particularly of sending a bill to the client once the win has crystallised, and then remitting to the client the balance of damages after the solicitor has deducted any sums claimed in the bill or shortfall linking to a success fee. And the question is, well, if you've done that, has time started to run for the purposes of subsection 70, subsection 4? Well, the short answer is not, unless you can show an actual or implied agreement to the actual sum deducted. So that's the issue. What's the context? The context here is against a background of facts really briefly as follows. The underlying retainer that Mr. Menzies had with his solicitors, Messrs. Oakwood, was a conditional fee agreement that provided for deductions by damages, which were capped overall to an amount equivalent to 25% of those damages. Oakwood sent various interim bills to the client prior to the between the parties settlement. And the between the parties settlement then, so far as costs were concerned, recovered about 18% of those profit costs. Oakwood Solicitors then delivered a statutory bill, and they made a refund on the same day of a sum that they'd held back from damages pending the resolution of the cost bill. And they deducted that sum of money and moved that from client account to office account. So as far as they were concerned, that was matters closed. Their client was now in a position to either question by way of a statutory assessment or general attack the amount of monies that had been deducted, the amount of monies that had been charged by way of costs. What in fact happened was this. Having sent a bill on the 11th of July, I think it was 2019, that filed a statutory bill, and adding that unless otherwise stated in the covering letter, the total charge deducted was as agreed, then what subsequently happened was approximately 2 years later, the client challenged the deductions. It matters not what deductions the client challenged for the purposes of this particular discussion. But the client obviously was, so far as Oakwood were concerned, out with the time provided by Section 70, subsection 4. So what happened was, it originally went into the Sheffield District Registry, and that was then transferred down to the Senior Court Costs Office in London. It came before Cost Judge Rowley. He heard the matter, and he held that payment for the purposes of Section 70, sub 4 had been made when the final statute bill was delivered. That matter then went on appeal before Bourne J, sitting with Cost Judge Simon Brown as an assessor. The High Court held that there was no payment because there had been no sufficient settlement of account. And that phrase settlement of account is, of course, a form of words that has its genesis in Victorian authority. Of course, it doesn't appear within the Act itself, but it is a form of words that the genesis of which I have to say is not overly clear, but it starts to pop up in Victorian times in various judgments, where it is used as a catch-all for there being having been some accord between the client and the solicitor as to the sums that were due to the solicitor. So that was the High Court. We then appealed, and we took that before the Court of Appeal. The Court of Appeal was a strong Court of Appeal. Sir Geoffrey Voss, the Master of the Rolls, and then Lord Justices Lewis and Simler. And there was I strongly recall the debate was had in front of the Court of Appeal on a particularly pivotal issue, and that was when Lady Justice Simler, obviously now a judge of the Supreme Court, questioned between bar and bench and asked whether or not this was in effect just a timing issue. And I recall the response to that was, yes, that is the nub of this, because in these circumstances, Oakwood Solicitors had a contractual arrangement whereby they had a right to do all of this. They had set what the cap was and told the client what the cap was. And then subsequently, they had told the client what that cap was in material, physical pounds and pence sense. And having done that, they had then taken their money, and there had been no complaint, in effect, for a significantly lengthy period. On that basis, the Court of Appeal found that payment for the purposes of Section 70 was to be taken as meaning a transfer of monies or its equivalent in satisfaction of a bill, and that will be so with the knowledge and consent of the payer. Furthermore, because the documents of retainer prospectively authorised the final charges and payment by deduction, the Court of Appeal concluded that upon the client being furnished with a final statutory bill, then the client had all the necessary knowledge to launch any particular inquiry into that bill, either by way of statutory assessment or otherwise. And therefore, what the Court of Appeal held was that what the client needed to agree was the transfer of monies, and not necessarily the pound, shillings and pence precise amount to be transferred. You could, in effect, have agreement prior via the retainer, and in effect, there was a complete agreement once there was no demur. And if you want to look at that, particularly read paragraph 42 of their decision, where, again, just to reiterate, they say the delivery of a compliant bill will give the client the necessary knowledge. The requirement of consent does not, in our view, require that consent be given after the delivery of the bill. If the client has already validly authorised the solicitor to recoup his fees by deduction from funds in his hand, what the client needs to consent to in order for payment to take place is the transfer of monies, not necessarily the precise amount to be transferred. That seemed to me to be an eminently sensible way of resolving matters. It seemed an eminently practical way of resolving matters, and it had, certainly we felt, a practical application in modern practice for solicitors. That was not the view of Mr. Menzies, and he therefore appealed to the Supreme Court. The Supreme Court took a differing view. The Supreme Court allowed the appeal, and having allowed the appeal, it's set out on the screen there, paragraph 71 of the sole judgment of Lord Hamlin, which the other Lord Justices agreed, effectively reverting back to this principle that what you needed was a very specific settlement of account, and that a settlement of account was ex post facto. In other words, what you had to know was what the sum of money was, and at that point in time was the point in time at which then there could be an accord as to the deduction. And at that point, once that settlement account had occurred, there was then the right to construe that what had occurred was a payment for the purposes of Section 70, subsection 4. And now the Supreme Court highlighted really the following bright line aspects of Section 70. They first of all found that the section of the Solicitors Act is concerned with this client's right to challenge solicitors' bills, and therefore they took the view that it would be surprising if the concept of payment was to occur without the client actually having any opportunity to consider the detail of the bill. So in other words, they found it would have been surprising to interpret the Solicitors Act, which of course permits under Section 70, subsection 1, a month without any fetter by which the client can challenge the bill. Their view was that it would be surprising if payment could have occurred before the effective elapsing of that month. They further found that the date of delivery of the bill is a central aspect to the statutory scheme. I have to say I don't disagree, because of course there is no, or there can be no time running under Section 70 until there is delivery of a compliant Section 69 statute bill. So the date of the delivery bill is clearly central, because all of Section 70 is predicated upon the happening of Section 69 and the delivery of a statutory bill. And therefore, it's at that point, and as a process, a sort of linear process, that you can see the time start to unfurl. And therefore, it's important to not lose sight of this 1 month that the client has as of right. They further went on to say that the section in the Act envisages of that period of time being allowed to reflux, and such accords, according to the Supreme Court's view, with the purposes of the regime, which is to protect the interests of the client and the client's right not to have to pay a bill until the assessment is completed, if they so choose. They also took the view that there was an obvious reason for a stricter regime that applies when the bill has been paid, which is, of course, what the what Section 70 does, because of course once you've had that payment and 12 months then elapses, you have this limitation, a defence in effect as a solicitor to the bringing of a Solicitors Act assessment. And so it's important. The Supreme Court looked at that particular section through the lens again of consumer protection, and very much thought that stricter regime, that narrower regime, that fetter to the client being able to seek to challenge a bill, was only understandable really through that lens of understanding that a client had been given an opportunity and had agreed to the sum that had been taken. Put differently, their view was that in circumstances where there is a fetter, that fetter should only be exercised when there is evidence that the client has agreed to the sum that's been deducted. So that brings us really to what's on the slide. The Supreme Court didn't go so far as to say that what you have to have is an absolute agreement, nailed on. This is the client saying, yes, I agree. The Supreme Court accepted that there could be an agreement in appropriate cases inferred from the party's conduct, and in particular from the client's acceptance of the balance claimed in the delivered bill. So in circumstances where you have sent and there is no demur, but there is inquiry as to that demur, or if you have terms within your retainer that permit, then the Supreme Court left open the notion that you could have in appropriate cases an inference from the conduct of the receiving clients that there was in fact an agreement. So that was the process by way of the progression of the claim. And what we had then had is we'd had an initial decision before Costas Rowley. We'd had a contrary decision by the High Court. We'd had a strong decision by the Court of Appeal. And then we'd had a turnaround again, but for different reasons, before the Supreme Court. I remind myself that, of course, the Supreme Court doesn't have to be right, but it does have to be final. But it's not for me to say whether they were right, because they are, because they've said they are. So that deals with what the issue is. That deals with the route that it was taken through the ranks of the judiciary. And it deals with highlighting what constitutes payment, what might constitute payment, and what potentially isn't payment. So what I'm now going to do is I'm going to hand over to Erica, and she's going to deal with the ramifications of what that decision means. Erica.
Yes, I'm going to talk to you about the ramifications, and this is broadly how we divided up the responsibility actually when we were in the Supreme Court. So the practical effects of it is also what we termed it. And I think as a starting point, it's really important to actually put Menzies in its context. I'm sure that there's been, it's been noted that there's been reference in some of the legal press that Menzies perhaps isn't going to have as wide repercussions as perhaps others might think. I'm and Mr. Ralph are obviously not of that view. Now, one may say that's because we're quite close to this, and I can see why you would say that. But then equally, it seems to me that the reason why Menzies is actually going to be quite important is because of how it deals with the notion of the understanding of payment. Absolutely. But it's the actual practical effect of what that is, because what it actually amounts to really is a limitation argument. And it's a limitation argument to ascertain whether a client is entitled at all to a Solicitor Act assessment, or whether the client is not entitled to a Solicitor Act assessment in specific circumstances, those specific circumstances being whether the bill has been paid or not. And that obviously has significant importance, particularly when we're looking back over the way a manner in which payment has been developed to be taken since the Jackson reforms, because as a consequence of that, we all know that the recoverable success fees and additional liabilities are no longer in the realm of the paying party defendant. They're very much in the paying party. Well, they are in the paying party client now. So as a consequence of that, practical billing processes have developed in order to take payments from clients, but in a very streamlined manner. And that's not just to ensure that cash flow is sensibly governed under accounting principles for solicitors' firms. It's also actually to ensure that we don't bother clients too much after their case is settled, particularly in the realm of personal injury clients who often are coming to terms with rather life-changing injuries and just want to get on with their lives. So these practices have developed, but importantly, the practices are very much developed on the understanding of what the current solicitors' accounts rules govern as to how one can take payment. And that's actually expressed under Rule 4.3. And what that requires is that there just has to be a written notification of transfer of money from client account into office account. So all that has to happen in terms of simply transferring the money. Now, Menzies does not override that. It doesn't. So one can still transfer money that is in your client account into office account after you've given written notification. But that is no longer going to amount for payment sufficient to satisfy Section 70, subsection 4. So we now have a disconnect between the professional rules and how the courts have understood the application of the Solicitors Act. Now, why is that important? It's important for this reason, because once Menzies is understood as being a limitation question and how a solicitor can protect themselves and avail themselves of the ability to say, this is a stale assessment and it dies here because it can't satisfy, because a client can't satisfy the limitation test, what you can actually see is that Menzies, put within its proper context, actually gives an understanding of where the limitation argument comes from. So what we don't want to do is for people to be concerned that they can no longer transfer money from office into client. You can still do that as long as it complies with the solicitor's accounts rules. But where you're going to have to be careful is where you deploy the defence of limitation as to the bill being paid. So that's where this actually goes to. And importantly, as I've said, historically, there was alignment between, or perhaps not historically, but there'd been an understanding historically that there was more of an alignment between the solicitor's accounts rules and Section 70, subsection 4. But Menzies drives a wedge through that. And that's why it's important to understand it, because if solicitors have gone and firms have gone and created billing practices predicated on the solicitor's accounts rules rather than how we understand Menzies, it's going to be difficult to rely upon that limitation defence. So what are we going to do about it? Well, the gold standard, as we now understand through Menzies, is that there has to be an agreement between solicitor and client after delivery of the statute bill. So the process is very much that you have it in your retainer that you can take deduction by way of damages, you settle the claim, you go to the client to speak to them about deductions before hopefully you settle the inter partes costs. You settle the inter partes costs, you're left with a shortfall, you can calculate the success fee, you create a statute bill dependent upon those figures, you send that statute bill and deliver it to the client in accordance with the provisions under Section 69, and then the client comes back and says, yeah, that's all fine, and then you work out the deductions and send the balance of money to the client. That's how we need to have the process under Menzies, and that's what's going to be the gold standard. And it's going to be very specific, of course, dependent upon the business profile and how solicitors wish to dedicate where they're going to be investing their fee earner time as to that process. But broadly, that's what's going to be the gold standard as we understand it from now. But equally, I'm sure that you can all see that that's perhaps not exactly what's been going on. So what we're going to, as a consequence now, if you've been having that gold standard, I might say, then you seem to be that there's going to be no particular problem with it. But certainly from my practice and our discussions about this with Craig and with also other practitioners, the gold standard that I've just taken you through is not necessarily something that's been prevalent over the course of the last 12 years. So it seems to us certainly that there are now going to be 3 categories broadly of cases that are going to have to be reviewed in light of Menzies. You've got your stale cases, that we termed stale. If you look, there's been reference to stale assessments cropping up in Solicitor Act authorities. I think the phrase actually came from prior Judge Gosnell sitting as the DCJ in Leeds on, I think, one of the Boudier cases. He used the word stale, and it very much aligns with his language. And I think it's a really useful phrase. It's quite visual. So it's these stale cases. And when we're talking about stale cases, we're talking about cases that you've already had the money in, you've already delivered your statute bills, you've already transferred the money, and they've been sat there for over 12 months. Those are the stale cases. We're going to need to deal with those very differently from how we deal with current cases. Current cases we categorise as those who are currently in process. So they're already under a retainer that you have that provides for deductions by way of damages. They haven't necessarily settled yet in terms of those damages, and they haven't necessarily settled yet in terms of the costs process and the billing process. Those are the current cases. You're going to really have to think about how you're going to handle those, but they're going to broadly have to be handled in a different way to how you handle the stale cases. Then we come to the third category, which is the future cases. And again, you're going to have to handle these slightly differently because these are the cases that you've not yet got through the door. So it's possible that you can amend the provisions in your retainer and thereafter your billing practices. So you have these very three distinct categories of cases. There is a window of opportunity such that one can tidy up retainers in the future cases, but there's not necessarily the window of opportunity to do that for the stale and for the current. So the stale and the current are more going to have to be managed by way of your cost lawyers managing the costs assessment process, because that's where you can really control your billing practices. So that's why it's important that we understand that there are three distinct categories of cases that are going to be affected and that we need to handle them all ever so slightly differently. So stale cases or cases over 12 months, as I've said, where there's been a payment by deduction and there's no client-specific agreement to the sum. And how do we deal with those? Well, again, this is very much going to come down to your specific firm. One's going to need to look at the retainer, one's going to need to look at the billing practices that you have. But in these cases, you boxed off, you put them to bed, you've not really had to think about them still. But these are the types of cases that, in our opinion, are very much going to be targeted, it's suspected, by the types of firms that support clients in bringing these assessments. So these are very much the stale cases, that they're the ones that they're going to be trying to go after because they're going to understand that these are probably more where the solicitor's risk is focused. So how do one manage those? Well, I would strongly recommend that these are very much managed by or overseen at the very least on a case-by-case basis by a cost lawyer who has some degree of specialism in Solicitor Act matters. The window of opportunity that has been created by paragraph 71 of Menzies is that the Supreme Court has left open this notion that there could be an implied agreement. And that's really important because what Menzies does not say is that it does not say you have to have an express agreement. They actually specifically go on and say, no, there can be an implied agreement in certain circumstances. Now, it's right that that comment is obiter. It's right that it is, but I would suggest that it's very strong obiter, and you're going to need a strong, I would suggest, lower court to move away from that which is set out in paragraph 71 and the understanding that there can be an implied agreement. However, implied agreement arguments are what we call nuanced. And put otherwise, and put bluntly and put shortly, that usually means expensive and risk-laden. Because what you're doing is you're throwing yourself on the mercy and effect of the court to show that all the normal ingredients of an implied agreement are present in these circumstances. And what the courts are very much going to be doing, it seems to me, certainly moving forwards, as Craig has already foreshadowed, is that they are going to be looking at these agreements or the notion of an implied agreement through the lens of consumer protection. It very much seems to be a watchword at the moment, no matter which decision of a Solicitors Act assessment appeal we're getting through at the moment. It's been put very strongly in Menzies, I think it was paragraph 43, where they spoke of the Solicitors Act has to be interpreted through the lens of consumer protection. If one looks back, there was a case of Boudia and Richard Slade last year where it was spoken about of this has to be looked through the lens of consumer protection. And this is very much something that is being a watchword now and is being seized upon, particularly again by those types of firms that bring these actions to say, well, this is all very much unfair. They've effectively done the superhero cloak of consumer protection. They put it on and this is how they run with it. This is very unfair. It's against consumer protection and clients are being need to have that layer of protection. That carrying call has very much been taken up by the Supreme Court now. So when we're looking at implied agreements to these sums, following delivery of the bill, one is going to need to have an understanding that the court is going to be viewing it very much through the lens of consumer protection. And what that means, I would suggest in reality, is that it's going to be more difficult for solicitors to find, historically anyway, until one can get to the future cases where we can manage that prospective billing process a little bit better, that the implied agreement argument is possibly going to be more difficult with viewing it through this consumer protection lens than it would be, for example, if one was viewing it from more of a neutral starting point. So that's something that you're going to need to do. What could amount to an implied agreement? It's a discretionary element, I suppose, isn't it? Not a discretionary element, but it's a very fact-centric element. If you have written to your client and you have billing processes whereby, for example, you get the client's agreement to the between the parties settlement and you've outlined in your letter that the consequences that between the parties settlement, not only on the success fee, but also on any shortfall that you're going to be deducted. And before you've had an agreement to the between the parties settlement, you get the client to agree those figures. And then the client agrees them, but then goes cold on you once you've delivered your statute bill. It may be more, there may be more ability to say that the implied agreement was there because, again, it's simply a timing process. But you're still going to have some agreement by acquiescence or effect when you're dealing with these implied agreements. So it could look something like that, although, again, you're going to need to have something after the delivery of the bill. And that's where it becomes quite difficult when you're looking at historic cases that you're trying to risk manage, because, again, that's very much what this is risk management, which is why I say it's very much is going to need a specialist cost lawyer at the very least to be looking at these. So that's one aspect. The second aspect is that you can say that there are the client will have to prove special circumstances under subsection 3 in the event that those cases are over 12 months old. So there is a cascading protection or rights of protection to a client, which are actually set out within section 70. A client's got an absolute right to an assessment within a month, within 30 days. Then there is a notional discretionary ability for the court to order a Solicitors Act assessment up to 12 months where there's been no payment of the bill and there's been no judgment. The reality is that they're usually going to get it. Anything over 12 months where there hasn't been payment, the client has to thereafter go and rely upon special circumstances. And this is very much where you're going to have to argue. There may not be payment, but you fall back on special circumstances. It's the burden on the client to prove that there are special circumstances, and you're going to have to address that and say, no, there aren't. And you're going to have to have the argument there. But again, what this comes down to is it's a nuanced and discretionary argument, which read expensive and risk-laden. And again, is going to be viewed very much through this lens of consumer protection. So not necessarily from that level playing field. It's going to very much more, in my opinion, moving forwards, be viewed through, well, where can this client be protected? So you're going to see more of the court having that more parental view over these types of cases. So those are the ramifications for the stale case, as I said, very much going to need to be managed via the costs process rather than anything else. We then move to the current cases, and in these, it seems that you've got a little bit more control, because if you've not gone through the billing process yet, you can implement certain aspects and implement certain steps. So you can create a little bit more of a layer of protection for yourself. Again, it's going to seem to be, in my opinion anyway, very much managed within the cost team rather than by fee earners during the currency of the claim. It's going to have to be looked at where you want to invest that time as to your fee earners and your cost practitioners. But when one is looking at the billing processes, very much look to where you can get specific agreements to between the parties' costs prior to sending the final statute bill. You then send the final statute bill and you're going to get an express agreement, hopefully, from the client, because they've already agreed to the between the parties settlement during the currency of the between the parties. So the deductions during the currency of agreeing between the parties settlement. And hopefully also you've got sufficient practices in place that throughout the currency of the claim, you've been giving your clients the relevant estimates that they're going to be entitled to in any event during the currency of the claim. So, for example, usually between every 3 to 6 months. So by the time the client gets to the end of the process, they're not surprised. They've had their expectations managed throughout the currency of the claim. So when it comes to those final deductions, there's no surprises, because it very much does seem to me that when clients get surprised, that's when they start to complain. And it would be with any human aspect. If you've got a builder coming in, they haven't given you estimates, apart from the one they told you at the outset when it's going to be £10,000. They then come to you at the end of the building process and they go, oh, actually, it's now going to be £40,000. Here's my bill, please. You're not necessarily going to be pleased about that. You're going to question it. But if there's been updates and estimates such that your hand has been held through that process and you have an understanding of what it is you are going to have to lay out at the end of it, and it doesn't come as a surprise, then it's less likely to lead to a complaint. The reality is that assessments are just a complaint about how much I'm being charged. So if you've got those processes in place, then you're going to be protecting yourselves a little bit better. The problem again comes with how do we deal with the intransigent client? And there was much discourse between bar and bench during the currency of the Supreme Court hearing as to how we deal with these intransigent clients. And the Supreme Court weren't particularly, they listened very politely, I think it's fair to say, but they didn't see that this was so much of a significantly problematic issue. One of the matters was that they said there was no evidence at all, and I think that's something that's referenced in the judgment itself, or no evidence that this had ever really been a problem. Well, I suggested that it hadn't really been a problem because, of course, the payments had been taken by way of deductions. But you have clients who will go to ground and don't answer you. And there's a variety of different reasons as to why that may be. It could be that you've just got a difficult client who doesn't want to speak to you. It could be equally within the context of personal injury claims, and particularly clinical negligence claims, that actually these people are dealing with life-changing illnesses and life-changing conditions, and they're trying to manage those, and being bothered by their solicitor about the payment at the end of it is not something they want to be bothered with. So you do have a spectrum of reasons as to why a client may go to ground and become intransigent, but it's how we deal with those as a profession so that we can rely upon this notion of payment by way of deductions so that you can protect yourself for a limitation defence. And again, it's the same issues. So we have this, can you rely on an implied agreement? You're going to need to tee that up for the same reasons, through the same reasons, forgive me. So if you have matters, for example, by way of the retainer provides for it, you've given sufficient estimates, you've got their agreements between the parties settlement, you've delivered the bill for exactly the same amount that they've previously agreed, but they've now gone to ground, you've had a 30-day period which has gone past, you still haven't heard from them, what do you do? Well, you can transfer the money under the solicitor's account rules, and you can sit on it and see whether somebody like James Green will come along and attack it later on down the line. Or one of the suggestions in the Solicitors Act, so in Menzies, was that you can launch your own assessment proceedings. Now, the judgment itself says that this can be a truncated process. And again, this was something that we discussed during the course of the hearing. And there was an example given helpfully within the bundle of the directions that were actually given in Menzies, and they were given by District Judge Batchelor sitting as a regional cost judge, and she has come up with various sensible ways of trying to truncate this process. But those directions still amounted to 2 pages. I would not suggest, and I did not, and I suggested this during the course of the hearing, that was not a truncated process. It was quite an elongated process that required investment by firms, which can be difficult. But again, that wasn't accepted by the Supreme Court either, and they didn't particularly deal with it, actually, did they, Craig? They just said, no, this can be a truncated process, and that's the end of it. Not particularly any evidence of how that can be. Certainly, there's no streamlined process in the civil procedure rules which can suggest that that can be done. So it seems to me that if you are going to have a truncated process, it's going to very much be left to the courts to deal with that, which is going to potentially, again, be problematic because it means you're going to have different processes in different courts. So what that's going to look like, I'm simply not sure. But we have been told by those on high that it can be a truncated process, though, you know, it may have been a bit more helpful for them to actually delineate out and tell us exactly what that could and should look like, but they haven't. So there we are. Are you likely to want to launch your own assessment proceedings? Again, that's going to be very much a business decision that you want to take. And what all these very much drive down to is a balancing act between how much investment your firm wants to make so that you can have more of a risk-free environment in which you are working, or whether you want to have a lower investment but increased risk. And that's going to very much be something that is a business decision driven by your business needs, and that's going to be very specific to each and every firm, I would suggest. Which then moves us into future cases. And I think these are actually quite an interesting category of case, because what we have, going back to paragraph 71 again, is that there can be implied agreements to the deductions. So how can we create an environment for solicitors so that they can push towards a greater certainty of obtaining an implied agreement? And one of the things that I would suggest is that one reviews retainers. It's always sensible to have health checks on these every 12 months anyway, but review retainers so that one can amend the payment clause so that it can say, for example, we will go through this process in order to ascertain and obtain your agreement to our fees. You then outline the process. You then say, we will then expect you, and it will be one of your responsibilities to respond to us. In the event that you do not comply with this responsibility, we will deem you to have impliedly accepted our fees by the following, and then you can set out what that conduct could potentially amount to, importantly delineating out that it is after you have delivered the bill. So this is very much something that you could do. Again, it's not risk-free, it is not a panacea, it is not something which is going to be absolutely nailed on to protect you. But what you are doing is you're putting yourself in the best situation possible, such that in the event that you want to deploy this argument of limitation on a Solicitor Act assessment, that it puts you in the best circumstance to be able to argue it. That's what this is about. So you amend your CFA to do that. You then amend the billing practices to the same way that I've already set out. You try and get their express agreement. If they go to ground on you, then you write to them and say, we've been chasing you. We're trying to get you agreement to this. You've already agreed to the figure. We now need you just to agree to the bill. In the event that you don't respond to us, etc., etc. So you can go through that and create that as part of your billing process in order to get their implied agreement in the event that you end up dealing with an intransigent client. Again, you can also look at the issue of launching Solicitor Act proceedings yourself, but for the reasons that I've already explained, I'm far from convinced that that's something that has business sense attached to it. There is this notion, again, that's in Menzies, I think it was paragraph 73, whereby solicitors could just, if solicitors wouldn't need to have as further an express agreement in circumstances where they've agreed to work for a fixed sum. I would suggest that that's a bit of a red herring in terms of CFA work, which is usually the way in which the market, the personal injury market in particular, deals with their retainers. It seems to me that that notion for a fixed sum is fraught with difficulty, not least that it could potentially blindly sleepwalk you into a DBA. And frankly, those are difficult creatures. But it may be that you want to change your billing practices such that you actually have, instead of working on a CFA, you work on a very fixed sum. That is a possibility. It may not be a favourable possibility, but it is a possibility. And if you have a prospective fixed sum, which is always what you're going to take, then you may be able to avoid this notion of ending in a situation where you have to have these very elaborate billing processes. But again, that's going to be something that needs specific advice given to your firm in your specific circumstances. So these are the three areas that we've certainly thought about as to the different aspects that really do need to be thought about. I can see that quite a number of you have put your hands up. Right, these are very specific questions with very specific answers to them. Really, what you are, in this case, the solicitor ever advised the client. We never knew, actually. It was 18, I agree, 18% was curious as to the between the parties settlement. It's something that we certainly never had an answer to. It was extremely low. It was a curiosity. And as I said, we certainly never had an answer to that. Will the recording be available? Yes, it will. Is it easier to write statutory bills to clients on multi-track claims? That's a specific question as to your billing practices. It's going to depend on, is the Solicitor Act ever going to be updated? Who knows? Everybody's been calling for it. And frankly, if they aren't going to be listening to Lord Justice Voss telling them to do it, the Master of the Rolls twice, they're certainly not going to be listening to little old me, I'm afraid. The Ombudsman issue. The Ombudsman issue is interesting. The Ombudsman's recently changed their practices to accepting these cases, and I would highly recommend that you go and look at them online. They've been amended in the course of the last few months. I know from having looked at them recently that the process is now that they will look at cases whereby they have been taken, or certainly that they've looked at, the complaint has been made in the course of the last 12 months. But where they take their starting point is very different to where the Solicitor Act takes its starting point. The Ombudsman takes its starting point as to the date of knowledge of the client, which usually, if you look at their guidance, runs from the date that the client was informed that they had a potential claim. So it's very different. It's a very different process. Certainly, Lord Voss suggested that this is the process that ought to be used in low-value claims. But given there seems now to be a disconnect between the Solicitors Act and where they take their starting point, or where the Ombudsman takes its starting point.
Yeah, I did read some of the questions. I heard you picking up on something about the legal ombudsman, Erica. My apologies to you, dear listener, or listeners, if you've stuck with us this long, for me going off. But it did strike me that there are two very dynamic takeaway points from all of this. The first is to understand that really the Supreme Court's decision could largely be seen as nothing more than part of that general movement that has increasingly occurred in the courts, really going back 10 or 15 years, starting with cases such as Myatt and Garrett, this idea that clients are at the whim and mercy of solicitors. And as a result of that, they need to be protected. Certainly that would appear to be my take on what is going on here with the Supreme Court, because many would say, well, why were they even interested in this question? And I do think it is very much that continuation of a desire to say that the Solicitors Act isn't fit for purpose and clients need protecting, and they need protecting because the consumer protections in other statutes simply don't cross over into the Solicitors Act. And so this is a reminder of that deficiency, and is part and parcel of the court's drive to make that point front and centre. And it's a point that should be known, or is known, by practitioners. The reality is we all know, because of 8.7 of the mandatory guidance of the SRA guidance, that the client needs to know at the outset and throughout what the costs are going to be. It's clear from the approach of the Ombudsman, who, as Erica quite rightly pointed out, have different time limits. What the Ombudsman is engaged with is this idea that clients aren't surprised and that requires you to interface with those clients. So that's the context in which I think this arises. But insofar as the questions that have been asked, I agree with Eric. Some of them are very fact specific. But can I just clear up one or two that seem to have a common theme? I don't know if Erica dealt with this while I was offline, but clearly, if you have an agreement with your client along the way to a deduction, it shouldn't matter that the statute bill then comes after it, because in fact, when one looks at the Victorian cases, they were that very set of circumstances. The client would come into the solicitor's office, the solicitor and client would discuss the bill, there would then be a reckoning and an agreement between them, and then upon that agreement being reached, the solicitor would go away, draw up the actual statute bill, and then give it to the client. So clearly, if you have an agreement before the bill, you have an agreement. It also, if you have fixed costs, if you agree an amount of fixed costs, or you don't look to your client for any shortfall, then a lot of these problems are not going to attenuate. They're just not going to occur. But I agree with Eric. What you shouldn't do is try to do some elaborate set of terms within your retainer that somehow, instead of using a percentage or a cap, try to weave an amount of shortfall costs in a number certain by reference to the damages. If you do that, you are likely to create a DBA, and you're going to have all sorts of problems with that, because in effect it's going to be a hybrid DBA with all the, regardless of Zuberian Lex law, that's going to throw up problems. So don't go down that route. The simple and short takeaway point really is, if you want to comply here, you have to simply move away from the notion that I think existed for quite a period of time, that it was enough to tell the client what it was they were having deducted, and then it was up to them to launch their own Solicitors Act proceedings if they didn't like it. The reality here is that would, I think, certainly in my opinion, not sit right with the approach of the legal ombudsman, wouldn't sit right with the discharge of your monetary obligations under the SRI guidance, and it certainly won't sit well with the decision in Menzies and Oakwood in the Supreme Court. So in effect, you almost have to go back in one form or another to that Victorian position, whereas when you get to the end, you need to make sure that you either have your client's agreement to what it is you are going to deduct in pounds, shillings and pence, or you need to secure it. Now, whatever route you take to that, whether it's the drafting of the retainer and cost updates as you go along, whether or not it's holding back some or all of the damages check until the client responds to you one way or the other, or whether or not it is the nuclear option, and it's not one I would encourage, where you say, well, I just can't get the client to do anything. Client won't launch Solicitors Act assessment proceeding. Client won't respond to me. I need to draw the line under this. So what I'm going to do is I'm going to launch my own Solicitors Act assessment proceedings. All of those are options that you'll have to address dependent upon the size of the file, the monetary influx that's coming from that particular file, and of course the firm's own view to risk. But there isn't a one size fits all. But what there is a contextual lens through which you can view it through, and that contextual lens is that moving forward, unless and until they change the Solicitors Act to bring it in line with consumer protection legislation, I would read the Solicitors Act, I would read the context of compliance, and I would look through the lens of the SRA guidance and the Ombudsman when addressing my client care retainers and client care letters and billing practices. And I would ask myself the question, is this consumer friendly? And if the answer is it isn't, then you're likely to come a cropper, or at least you're going to find yourself in potentially expensive litigation. So I think I opened this up before both Erica and I started waffling, that we would take 40 minutes. I now note that we are 4 minutes of taking an hour. My apologies. Because I've changed machine, I can no longer see the questions that are being asked. I don't know if Erica can, but what I'm going to do is go silent to allow Erica to top and tail this, given the fact that I can no longer see anything and I'm working off a different machine.
Absolutely. The chat is left as at 17:23. It's broadly that which we've discussed. The there was a theme which you've addressed. Otherwise, they're very specific factual questions which aren't really capable of being answered as part of a seminar. They're more specific factual questions that need to be answered within a factual context. Other than that, all we want to do is thank everybody for coming to listen to us. There was, at the height of it, I think just under 450 people, which we are thrilled to have on board, and it's very kind of you to spare your time and your Wednesday afternoon coming to listen to us talk about our very sore loss in the Supreme Court. But nonetheless, we had a lovely day, didn't we, Mr. Ralph? We had a lovely day, and we've been very thrilled to be able to talk to you all about it. And if there's anything specific in terms of anything else, then it's really going to have to be, I think, a question of more fact-specific advice, which is what we've spoken about. But other than that, we just want to say thank you, don't we?
We do. I understand that the slides will be sent out. I also understand that this will be posted on King's Chamber's website. So if you feel that the urge to impose this on somebody that had the temerity not to join in, you can download it and bully them with it. So thank you very much. And it's goodbye from me.
That's goodbye from me.